application that has been brought by the prosecution this morning. And in as much as the prosecutor would want you to believe that he needs an affidavit, what have they gone to do so far? They have actually gone ahead and opposed the application that we intend to make for bail. And you're given grounds. The first ground you're being given is you're being told that Mrs. Ononga, who appears for the state together with my colleague Mr. Njue, has got other duties. And so therefore, today he cannot be in court. She cannot be in court, sorry. First of all, Your Honor, the prosecution is a whole office by itself with various prosecutors, very many of them. So therefore, that one of them is not present today does not stop the process. In any case, Your Honor, every person's first duty is to court. So they cannot come here today and tell you that somebody has gone for some other work in the coastal province. Does that stop the rights of the accused person at this particular moment to be granted bail because somebody has gone to visit other places? They have not even given you a document to that effect or anything to show that. You know, today we were in court number 8. The state has just withdrawn a miscellaneous application 821 of 2021. They have withdrawn it today. They indicated to court that they are ready to charge the accused person. This is something that they had known from before. And if the police intended to oppose this application, they would have come with an affidavit. But they have failed to do so. In that application, which they had requested for 14 days, the court granted them 7 days. Today is 7 days later, and they are not ready. Your Honor, that cannot even be fair. Counsel tells you that the victim is in critical condition. We appreciate that. Isn't that the reason why the accused person has been charged with attempted murder? Isn't that the reason why? If the person recovers, if the victim recovers, it still remains attempted murder. If the condition changes that the suspect, and we pray that it does not happen, passes away, it becomes murder. So if you're being told that the victim is in hospital, and we are saying that we are sorry that that is the position, how does that change anything? How can that be connected to the accused person at this particular moment with this constitutional right? It is fair enough that they had been given 7 days. Now they're asking for Tuesday. The state is not ready, Your Honor, and that cannot delay the rights of the accused person. You're being told that another reason is because the victim cannot speak. And so therefore, the investigating officer who is in court today has not recorded his statement. The accused person cannot speak for that victim, cannot. So why do they want him in custody for that period of time? Because the victim cannot speak? Your Honor, we are saying this, putting in mind that the accused person has denied these charges. So the presumption of innocence starts from that moment on. So the issue of the victim speaking or not at this particular moment, Your Honor, cannot be a reason. You know, counsel for the victim has told you that the victim is in hospital, has undergone surgery. And has told you that the victim has got a constitutional right. He did not say which constitutional right is being infringed at this particular moment for this accused person to be released on bail. What exactly is that right that is not being visited upon him? Which one exactly? And so he supports that the accused person stays in custody. For what reason? For what other reason? Your Honor, in the absence of an affidavit in court today, whereby you have not been given any good reason, then the state cannot stand and tell you that it is opposing that the accused person be released on bail, or to canvass for it. And this is why the state then must realize Article 19 is very clear on these issues. In the absence of any reasonable grounds, once the accused person has been brought to court, his fundamental rights under Article 19 belong to him and not to the state. Belong to the accused person and not to the state. And that is because the accused person today is the favorite child of the court. The moment he is brought to court, his fundamental rights start immediately, not to be curtailed immediately. And being a state officer, and counsel being an officer of the court, they are bound by Article 21, which is clear that any official and state officer, police, the court, are bound. And they must start by wanting to grant those rights. Wanting to grant, not wanting to stop. Everybody is bound. And so today when they stop you, when they make that application, we must come to you under Article 23. Once we notice that they are intending to curtail those those rights, then 23 gives you the right to then grant those rights. So without any compelling reason, you must grant your own. Your Honor, counsel admits the accused person's parents went to visit the family. What does that show, Your Honor? It shows good faith. It shows that other avenues can be pursued. Why are we denying that person ground in the process? I would not even be embarrassed, Your Honor, today to stand and say that as you address the issue of bond, you can even grant the accused person free bond. And this is why I'm saying it. The accused person surrendered himself to the police officers. The investigating officer here knows it today. I went with him personally. I surrendered the firearm, which you're being told is going for ballistics, which they don't need the accused persons because he's not a ballistic expert. But we brought it to the station. I presented him there. That again shows good faith. So if they want to wait for all these things to happen, the person to heal, the victim, or Mrs. Onunga to come back and prepare an affidavit, in the meantime, release the accused person on bond. He's been in custody far too long. Far too long. That is all we wish to state.
Kabudi Musyoka, who is a police officer attached to DCI's director, was injured by the suspect on 3rd July, 3rd of July this year. Attached DCI Starehe. And allegedly was injured by the suspect on 3rd July by gun shooting somewhere along Thikaroad. On 6th July, he was still unconscious and had not spoken to anyone, and underwent surgery in Nairobi Hospital for 13 hours around his neck, which included several specialists due to the sensitivity. I'm happy to note that the parents of the accused person visited Mr. Festus Kafuthi at Nairobi Hospital and also met the family of Festus Kafuthi Musyoka. And they actually, the mother who is in court, wished him quick recovery and hoped the matter would be sorted someday. But unfortunately, up to now, after the surgery, he still has not recovered fully. Nothing much has changed. He's still in ICU. And he has not managed to talk to anyone to date. In fact, I received a note from Nairobi Hospital this morning for purposes of updating the court. So it is our prayer that first Mr. Kafuthi recovers, and also, if possible, as much as the suspect has constitutional right, the victim also has a constitutional right of retribution and the duty of care. And therefore, it's our prayer that while the state organizes itself, there are many issues to be looked at, whether the gun was lawful or not, the circumstances relating to this matter, and if the worst happens, the charges will change. So, hoping that you will recover by Tuesday, we pray that he's detained. I want to support the State Council in his prayers.
For bail, he had instructions to do so, and then we were asked to come to this court. Probably you can now proceed.
I confirm that that is the position. My instruction is that the state is opposing the release of the accused person on the bail or board terms. However, Your Honor, my further instructions are that I seek that we adjourn the issue on confessing the issue of the bail to Tuesday next week. On these accounts. One is that the prosecutor sees with the matter. That is Madam Onunga is out on another assignment in the coast region. And as such, she was not in a position to sit with the investigating officer, render her counsel in preparing of the affidavit in the position to the body. Now, Your Honor, that brings me to the appreciation of the law that the state, in opposing the board, need to give sufficient grounds, and it is unappealed. And the most appropriate way is by having depositions present before the court to assist in the determination of the case. And that's what Ms. Onunga is praying for time to do. Of course, in conjunction with the investigating officer. The second reason, Your Honor, that the state would be opposing the bill is that the victim in the first count is in a critical condition, and to this moment he has not managed to speak with the investigation officers, despite having undergone a surgery. We are hopeful that his condition may improve, and if possibly by then, the Tuesday that I'm praying for, he will have managed to speak with the investigating officers and give his statement. Your Honor, I appreciate that bond or bail is a constitutional right. And that's Article 49H. But again, it's my appreciation that there's no constitutional dictate that the issue of the bond must be determined immediately on charging an accused. There's no similar dictate like the one of presenting a person before a court within 24 hours. And on that account, Your Honor, it is my submission that waiting till Tuesday next week will not be a breach of the accused person's constitutional rights. And further, it will not be prejudicial. The last instruction that I have, Your Honor, is that in the meantime, before we can first issue the bill, we have the accused person detained at the Mararo police station. As that is the place that he has been held, following the order of the court in an unextraneous application. Your Honor, those are my prayers.
Your Honor, your kind permission.
Your Honor, to put the record as correct, I'm appearing, but warning me for Miss Onoga, who is in conduct of this. Your Honor, to put the record as correct, I'm appearing, but warning me for Miss Onoga, who is in conduct of this.